I'm not a lawyer and this is not legal advice. Don't consider it to be. These videos are intended for most people and they assume that you are an adult not prohibited from possessing a firearm. Be sure to check out this URL and look up these rules and regulations on your own. So ORS 166, 300, 320, and 330 aren't going to apply to those of us that are normal law-abiding citizens exercising our rights to carry, whether concealed or openly. So we're not going to cover those. 350, however, is unlawful possession of armor-piercing ammunition. That could come into play, so we'll cover that. 360, definitely. Definitions for ORS 360 through 380. 370 is possession in public building or court facility. 373 is possession in a court facility by a peace officer or federal officer. Doesn't apply to most of us. We don't care. 380, very important, examination of a firearm by a peace officer. 382, 384, and 385 don't apply. We're going to cover 4 out of the 300's series of Chapter 166. ORS 166-350, unlawful possession of armor-piercing ammunition. A person commits the crime of unlawful possession of armor-piercing ammunition if the person makes, sells, buys, or possesses any handgun ammunition with the bullet or projectile of which is coated with Teflon or any chemical compound with properties similar to Teflon, which is intended to penetrate soft body armor, such as a person having the intent that the ammunition be used in the commission of a felony, or carries any ammunition described in that paragraph while committing any felony during which the person or any accomplice of the person is armed with a firearm. And handgun ammunition means ammunition principally for use in pistols or revolvers, notwithstanding that the ammunition can be used in some rifles. Now, here's the problem with that. Teflon coating of ammunition is so that armor-piercing ammunition won't tear up the barrel. It has nothing to do with making the bullet slide through body armor. It's simply to keep wear and tear on the barrel down. Moly-coating bullets are the same thing. They're supposed to slide through the barrel better, cut down on wear. In the big picture, it's best just to avoid any kind of bullet in your pistol ammunition that's got any of these coatings on it. But the rule is ridiculous. That's 166-360's definitions for use in 166-360 to 166-380. So it's used in 166-360 to 166-380 unless the context requires otherwise. A court facility means a courthouse or that portion of any other building occupied by a circuit court, the Court of Appeals, the Supreme Court, or the Oregon Tax Court, or occupied by personnel related to the operations of those courts, or in which activities related to the operations of those courts take place. So there may not be a sign telling you it's a court facility. Of important note here, I don't see municipal court listed. A loaded firearm means a breech-loading firearm in which there is an unexpended cartridge or shell in or attached to the firearm, including but not limited to in a chamber, magazine, or clip which is attached to the firearm. A muzzle-loading firearm which is capped or primed and has a powder charge and ball, shot or projectile in the barrel or cylinder. Public building means a hospital, capitol building, a public or private school as defined in 339 and 315, college or university, city hall, or the residence of any state official elected by the state at large, and the grounds adjacent to each such building. It also includes that portion of any other building occupied by an agency of the state or a municipal corporation, and it's other than a court facility because that has its own regulations. Municipal courts are not in the definition of a court facility, but notice that it does include facilities occupied by the personnel of the courts it does mention. The state of the law is that you should be able to carry in a municipal court. Now, do you want to push your luck? It's up to you. I'm not a lawyer. You make your decisions. Also note that for 360 through 380, for a breech-loading firearm to be loaded, the unexpended cartridge must be in or attached to the firearm. Cartridges in a magazine that is not attached to the firearm do not constitute a loaded firearm under state law. However, Portland's local ordinance includes loaded magazines that are not attached as a violation. While this is obviously a violation of state law and preempted, it has not been tested in the courts, being that test case could be a very expensive endeavor. For a muzzle-loading firearm to be loaded requires it to be capped or primed and have a powder charge and ball, shot, or projectile in the barrel or cylinder. If you load your muzzle loader but do not cap or prime it, it's considered unloaded by state law for the purposes of 360 to 380. This does not necessarily mean that it would not be considered loaded for the purposes of 166-250 if you had it in your vehicle, for instance. And a public building does not include non-governmental, i.e. private property buildings, such as malls and stores open to the public. Only those specifically listed in governmental buildings in general, though court facilities fall under their own special regulation. So, public building has nothing to do with whether it's open to the public. It's got to be government or some sort of municipality owned. So 166-370 is possession of firearm or dangerous weapon in a public building or court facility. Exceptions: and discharging firearm at school. Any person who intentionally possesses a loaded or unloaded firearm or any other instrument while in or on a public building shall, upon conviction, be guilty of a Class C felony. You don't want felonies. Except as otherwise provided in paragraph B of this subsection, a person who intentionally possesses a firearm in a court facility is guilty upon conviction of a Class C felony. A person who intentionally possesses a firearm in a court facility shall surrender the firearm to a law enforcement officer. B has been edited because it doesn't relate to firearms. 370 subsection 3 says that subsection 1 of this section does not apply to a person who's licensed under 291 and 292 to carry a concealed handgun. Possession of a firearm on school property, if the firearm is possessed by a person not otherwise prohibited from possessing firearm and is unloaded and locked in a motor vehicle. Exceptions listed in 3B to G of this section, which is D and G that we just covered, constitute affirmative defenses to a charge of violating subsection 1 of the section. So it's not an exemption, it's an affirmative defense. And that can be a bit of a nuance that a lawyer would have to deal with. For 370, subsection 1 prohibits carrying a firearm in a public building. Subsection 3 exempts persons with a CHL from subsection 1. It does not exempt CHL holders from the prohibition on carrying in a court facility contained in 370 subsection 2. Very important. ORS 166-282 also exempts Oregon CHL holders from 370 subsection 1 by prohibiting law enforcement from arresting a CHL holder who has his CHL in his possession. Now, it can be argued that it's not illegal to carry in a public building without your CHL in your possession, though with one having been issued to you. However, it's likely going to end up in an arrest, as 166-282 would not be available for protection. And then you're going to have some fees and expenses and a little bit of inconvenience, but you can probably get out of the charge. And as a warning, check 166-380, as there is a firearms inspection provision that CHL holders must comply with when in or on a public building. You've got to let them inspect your firearm. Even though you're perfectly legal to have it loaded, they get to check your load condition if they really want to. And that brings us to 166-380, examination of firearm by a peace officer and arrest for failure to allow such examination. Subsection 1 tells us that a peace officer may examine a firearm possessed by anyone on the person while in or on a public building to determine whether the firearm is a loaded firearm. Subsection 2 tells us that refusing to allow that examination constitutes reason to believe that the person has committed a crime, and the peace officer may make an arrest pursuant to 133-310, which is basically how they arrest you. Now here's the problem with this. It's unsafe. It needs to be removed from the statutes. Until then, it must be complied with. This regulation creates an unsafe situation in which an officer is handling a firearm which he may or may not be familiar with. Since firearms and holsters do not discharge by themselves, but rather when they are being handled, this regulation creates an unsafe situation for the public. If a person presents a CHL, then they are absolutely within the law to have a loaded firearm while in or on a public building, and it should not be handled unnecessarily. If a person does not present a CHL, then they can be arrested, at which time law enforcement can inspect the firearm to their heart's content. 380 needs to go away. The ORS sections I just covered have more information, and you should make a point of reading the entire sections yourself. Use this video and the others in the series to point you in the right direction and give you an introduction, but do your own research. You can find all of the ORSs by going to the URL www.leg.state.or.us/ORS. And while you're at it, please click like Tell your friends about this video series, and if you find them informative, please click on an ad or two to help support putting out more. Open Carry USMC here on YouTube. Thanks for watching.